Good day to everyone. Our menu for today is all about the crime of rebellion as defined and penalized under Article 134 and 135 of the revised Penal Code. How is rebellion or insurrection committed? The crime of rebellion or insurrection is committed by rising publicly and taking arms against the government for the purpose of removing from the allegiance to said government or its laws the territory of the Philippine Islands or any part thereof, or any body of land, naval, or other armed forces, or depriving the chief executive or the legislature wholly or partially of any of their powers or prerogatives, as amended by Republic Act 6968. These are the elements of rebellion. Number one, there is a public uprising and taking arms against the government. And number two, the purpose of the public uprising and taking arms against the government is either to remove from the allegiance to said government or its laws the territory of the Philippines or any part thereof, or any body of land, naval, or other armed forces, or depriving the chief executive or Congress wholly or partially of any of their powers or prerogatives. Now, what is the nature of the crime of rebellion? In the case of People versus Lovedioro, the Supreme Court had occasion to mention that the gravamen of the crime of rebellion is an armed public uprising against the government. And by its very nature, rebellion is essentially a crime of masses or multitudes involving crowd action. What are the takeaways here? First, the Supreme Court did not mention the specific number of people that would be enough to constitute a rebellion. It merely uses the phrase crime of masses or multitudes involving crowd action. Also, the case and even the provision itself did not mention the nature of the arms to be used by the offenders or by the rebels who want to overthrow the government. And of course, it is required that it must be a public uprising. When you say public uprising, it is not necessary that the offenders or the so-called rebels should go out of their houses and go to the public plaza and declare the overthrow of the government in order to constitute a rebellion. When you say public uprising, it simply means that the public must be made aware of the purpose of the offenders, why they are taking arms against the government, and that is to overthrow the government, the duly constituted government of the Philippines. And you might ask, Fiscal, sufficient na ba yun kung mga bladed weapons lang ang gamit, mga sundang, mga kutsilyo, or any other weapon which is not a firearm? Would that be enough? Of course, it would not be enough. It would be impossible to overthrow the government merely by using bladed weapons. However, take note that an actual clash of arms with the forces of government is not necessary. Rising publicly and taking arms are enough to constitute the crime. But take note also that the purpose of the uprising, which is to overthrow the government, must be known. Must be known by whom? It must be known by the public. That's why it's called a public uprising. And there must be evidence showing such motive or purpose. Because in the case of US versus Constantino, merely attacking policemen and kidnapping the municipal officials are not enough to show or to indicate that a rebellion is taking place or that the offenders are engaging in a rebellion against the government. The motive or the reason or the purpose must be shown. What I mean by this is the attack against the policemen and the kidnapping of the municipal officials must be shown to be one of the manifestations, so to speak, of their intention to overthrow the government by the use of force. And it is also not necessary that the purpose of the rebellion should be accomplished or that the rebels succeed in overthrowing the government. Why? Because if they succeed, they will no longer be prosecuted by the new government that they helped establish. Who will prosecute them if the rebels succeed? If they succeed, they will be the new government. And the people manning the old government will be the one prosecuted instead. That would be the result, no? If the rebellion is accomplished, or the purpose rather of the rebellion is accomplished, that is to overthrow the government. So the overthrow of the government is not necessary because, to repeat, merely rising publicly and taking arms are enough to constitute the crime. And of course, with the requirement that the purpose of the offenders in rising publicly and taking arms is for the purpose of overthrowing the government. Also take note that rebellion is a continuing crime or a continuing offense. And I have already discussed to you the nature of a continuing offense. Okay? And that discussion was discussed, in my previous video. So all you need is to scour the videos I posted in YouTube and listen to them again. Hence, for as long as the rebel continues to take arms against the government, he can be arrested at any time, even without a warrant. Again, rebellion is a continuing crime. And since it is a continuing crime, for as long as the rebel continues to take up arms against the government, as ruled in the case of Garcia-Padilla versus Enrile, the rebel can be arrested at any time, even without a warrant of arrest. Is it necessary that there be an overt act constitutive of rebellion taking place in the presence of the arresting officer before the rebel can be arrested without a warrant? The answer is, it depends. For example, X has openly declared himself to be a member of the CPP-NPA. In other words, there is evidence, like for example a video footage showing X carrying arms in the mountains as part of the said rebel group, or showing him holding press conferences on behalf of the CPP-NPA. I remember many years ago, Roger Rosal was the face of the CPP-NPA. I usually see him on TV holding press conferences for the CPP-NPA and negotiating. He is the point person of the NPA with respect to the negotiations for the release of hostages, hostages of the NPA. And during press conferences, you can readily observe rather that he is speaking, or he was speaking on behalf of the CPP-NPA. Now, in such a case, even if there is no video footage that he was carrying firearms, he can be arrested without warrant, even if at the time of the arrest, he was not doing an overt act in pursuit of the rebellion. So, let us say, Ka Roger Rosal was seen traveling by way of motorcycle or by way of bicycle, no, traversing the streets of a certain municipality. At that point in time, he was not doing an overt act in pursuit of the rebellion. Generally, there is no crime, or you cannot arrest a person while riding a bicycle, because that is a legitimate act. There is nothing illegal about it. But because he has been identified as a rebel, and there is already evidence that he has already openly declared himself to be a member of the New People's Army, a guerrilla organization or an armed organization which is in open rebellion against the duly constituted government, then he can be arrested even without a warrant. On the other hand, if X has not openly declared himself to be a member of the CPP-NPA, or that there is no evidence that he is indeed a rebel, he cannot therefore be arrested without warrant. He can only be arrested without warrant under the circumstances of a valid warrantless arrest as provided for in Section 5, Rule 113 of the Revised Rules on Criminal Procedure. I'm talking about in flagrante delicto and hot pursuit arrests. Now, on December 9, 2020, the Anti-Terrorism Council, pursuant to its mandate under the Anti-Terror Law or RA 11479, issued ATC Resolution number 12 declaring the CPP-NPA as a terrorist organization. According to the Anti-Terrorism Council, the CPP-NPA was organized for the purpose of engaging in terrorism and for almost half a century have been and are still using acts of terror to sow and create a condition of widespread and extraordinary fear and panic among the populace in order to overthrow the duly constituted authorities and seize control of the Philippine government through armed struggle. What is the implication of this ATC resolution? A rebel, assuming there is evidence that a person is indeed an NPA combatant, he can now be charged with either rebellion or with the crime of terrorism as provided for in RA 11479. Because mere membership in a terrorist organization will already make the person liable under Republic Act 11479. But I will have a separate discussion on the new anti-terror law which repealed the Human Security Act in a separate video. In the case of Umil versus Ramos, the Supreme Court made the following pronouncement. Given the ideological content of membership in the CPP-NPA, which includes armed struggle for the overthrow of organized government, X did not cease to be subversive or became less of a subversive for purposes of arrest simply because he was, at the time of arrest, confined in the St. Agnes Hospital. X was identified as one of several persons who, the day before his warrantless arrest at the St. Agnes Hospital, had shot two policemen in their patrol car. That X had shot the two policemen in Caloocan City as part of his mission as a Sparrow or an NPA member did not end there and then. Dural, one of the companions of Umil, given another opportunity, would have shot or would shoot other policemen anywhere as agents or representatives of organized government. It is in this sense that subversion, like rebellion or insurrection, is perceived here as a continuing offense. Unlike other so-called common offenses like adultery, murder, arson, etc., which generally end upon their commission, subversion and rebellion are anchored on an ideological base which compels the repetition of the same acts of lawlessness and violence until the overriding objective of overthrowing organized government is attained. Now, you must remember that at the time this case was decided, the anti-subversion law was still in effect. I am referring to Republic Act 1700. And when you say subversion, the crime of subversion is a crime against the national security. It was enacted, or the law against subversion was enacted to outlaw precisely the CPP-NPA or other similar organizations and its successors, because according to that law, the existence of the CPP-NPA and activities constitute a clear, present, and grave danger to national security. And I agree, because this organization exists to precisely overthrow the duly constituted government. And that was the reason why the anti-subversion law was enacted. Mere membership in that organization is enough to constitute the crime, and as applied in the case of Umil versus Ramos, there was a petition for the release of Umil and his companions because, according to them, the arrest was illegal because they were arrested without warrant, and they were arrested when they or some of them were being treated at St. Agnes Hospital. They were confined there, no, at St. Agnes Hospital, and the military authorities proceeded to arrest them. And according to them, the arrest was invalid because they were not committing a crime while being confined at the hospital. But the Supreme Court did not side with their argument. The Supreme Court said that mere membership in a subversive organization like the CPP-NPA was enough. But more than the crime of subversion, there was also evidence showing that a day before their confinement at the hospital, they were positively identified as the person or persons who shot and killed 2 policemen. And their attack against that policeman had a political motive because they were members of the CPP-NPA, members of the dreaded Sparrow unit at that time. Now, that was the reason that the Supreme Court gave in validating their warrantless arrest, because according to the Supreme Court, their warrantless arrest can come under Section 5B. I am referring to the doctrine or the arrest based on hot pursuit. There was probable cause on the part of the military and police authorities to arrest them because it engendered in the mind of the military authorities and police officers a well-founded belief that they were, based on the identification of witnesses, they were the persons who shot and killed 2 policemen the day before their supposed warrantless arrest. So their arrest, in short, was based on probable cause under Section 5B, Rule 113 of the Revised Rules on Criminal Procedure. So in this case, there were 2 legal grounds that the Supreme Court advanced to justify the warrantless arrest of Umil and his companions. First, the ground that mere membership in a subversive organization like the CPP-NPA is already a crime in itself, and at the same time, their identification, the positive identification by witnesses that they were the ones who shot and killed the two policemen a day before. And that was enough, according to the Supreme Court, to constitute probable cause, justifying their warrantless arrests. However, later, in 1992, if I remember right, Republic Act 1700 or the Anti-Subversion Law had been or was repealed. Okay. But that has been cured, so to speak, because at present, the CPP-NPA, although there is no more anti-subversion law, the CPP-NPA has been declared by the Anti-Terrorism Council as a terrorist organization, pursuant to its mandate under Republic Act 11479. Now, I will not discuss the constitutionality of the said anti-terror law. I will leave that to the Supreme Court and to the proponents of the petition to declare its unconstitutionality. But considering that there is yet no declaration of unconstitutionality, we have to abide by the statutory principle that a law is presumed constitutional. And that is the reason why I am discussing or mentioning the resolution of the ATC declaring the CPP-NPA as a terrorist organization. And to repeat, since the CPP-NPA is already or has been declared as a terrorist organization by the ATC, although there is yet no judicial declaration of them as a terrorist organization, the military and police authorities would now have an additional reason to create in them or to create in their minds probable cause to effect the warrantless arrest of persons seeking to overthrow the government. Okay. But I would also advance the argument that mere identification of certain persons as belonging to the CPP-NPA would not be enough. There must still be what? Or the arrest must still be based on the instances of a valid warrantless arrest under Section 5B of Rule 113 of the Revised Rules on Criminal Procedure. This was what I was talking about earlier. Okay? At the time Umil was decided, the anti-subversion law was still in effect. The law was enacted to outlaw the CPP-NPA because, as I said, its existence and activities constituted a clear and present danger to the national security of the country. However, in 1992, Republic Act 7636 was enacted precisely repealing the anti-subversion law. So, at present, there is no more crime of subversion. Subversion, the crime of subversion has been decriminalized. And like what I said a while ago, in the Umil case, X was arrested not just because he belonged to a subversive organization, but more so because his arrest was justified under Section 5B, Rule 113 Supra. What happens if common crimes like murder or kidnapping are committed in furtherance of the rebellion? Will they be absorbed in rebellion or will they stay as separate crimes? Again, in People versus Lovedioro, the Supreme Court noted that one aspect noteworthy in the commission of rebellion is that other acts committed in its pursuance are by law absorbed in the crime itself because they acquire a political character. So, this precisely answers the question. I pointed out earlier, what happens if common crimes like murder or kidnapping are committed in furtherance or by reason of the rebellion? It becomes what? Absorbed in the crime of rebellion itself. Because although they are common crimes per se, but they have already acquired a political character, according to the case of People versus Lovedioro. Now, how do we know that they have acquired a political character? In the old case of People versus Hernandez, which is still the controlling case insofar as rebellion is concerned, political crimes are those directly aimed against the political order, against the state, as well as such common crimes as may be committed to achieve a political purpose. The decisive factor here is the intent or motive of the offender or offenders. If a crime usually regarded as common, like homicide, is perpetrated for the purpose of removing from the allegiance to the government the territory of the Philippines or any part thereof, then it becomes stripped of its common complexion, inasmuch as being part and parcel of the crime of rebellion, the former acquires the political character of the latter. So there can be no more clearer explanation than what was declared in the case of People versus Hernandez. All crimes committed in furtherance of the rebellion are deemed absorbed in the rebellion itself. And if I may to add further, which I will explain in the later slides, even those common crimes that are committed or that are not committed or that are committed not in furtherance of the rebellion, but they were committed during the course of the rebellion, are also deemed absorbed in the crime of rebellion itself. In other words, Article 48 of the Revised Penal Code on complex crimes, whether it is a complex crime proper or a compound crime, will not apply insofar as rebellion is concerned. There is no complex crime of rebellion with murder or rebellion with kidnapping. Only a single crime of rebellion shall be filed against the offender. Now, if common crimes such as murder, kidnapping, or robbery are committed in furtherance of the rebellion, take note, there will only be one single crime of rebellion to be charged against the offender or offenders. The common crimes will lose their separate complexion as common crimes and will become absorbed in the rebellion. And also take note that when I say there should only be one crime of rebellion to be charged, there should only be one, not 2, 3, 4, 5, or 6. Despite how many acts are committed in furtherance of the rebellion. What's the reason for this? The reason is because no matter how many acts are committed by the offender or offenders in furtherance of the rebellion, there is only one crime because the offender or offenders are impelled only by a single criminal intent. Now, why is it important to determine whether the common crime like murder was committed in furtherance or during the course of the rebellion? It is important because of the disparity in the penalties between, for example, rebellion and murder with respect to the offender who merely participates in a rebellion like an NPA rebel or combatant. Take a look at this. In rebellion, the imposable penalty is only reclusion temporal. If, let's say, X, a rebel, is found guilty of rebellion, he will only be meted the penalty of reclusion temporal despite the fact that he killed someone, like a policeman, for which reason he was arrested, tried, and convicted. because the charge is only rebellion. And rebellion, as provided for in Article 135, to repeat, only has an imposable penalty of reclusion temporal. Now contrast that with the crime of murder. Same example, X, a rebel, was charged of the crime of murder. If proven guilty, he will be imposed the penalty of reclusion perpetua, which is definitely 1 degree higher than reclusion temporal, 20 years and 1 day to 40 years. So that is the reason why there must be a determination that the common crime was committed in furtherance or during the course of the rebellion. Although, with respect to the offender who promotes, maintains, or heads a rebellion, the penalty is the same as that of murder, which is reclusion perpetua. So whether the promoter or the head of the rebellion is charged with rebellion or murder, as the case may be, it is already of no moment because the imposable penalty is the same. Let us go through some examples here. Example number 1. X, Y, and Z, members of the NPA's dreaded Sparrow unit, assassinated the chief of police for his alleged abuses and crimes against the Filipino people. Here, the murder of the chief of police assumes a political character. Why? Because it is clear, based on the facts of the case, that it was committed in furtherance of the rebellion. Hence, only a case for simple rebellion should be filed against X, Y, and Z. What about Fiscal, the killing of the chief of police? Isn't it, or doesn't it constitute the crime of murder or direct assault with murder? The answer is no, because in this example, we are assuming that these are the facts of the case, meaning to say we are assuming that it is established that X, Y, and Z are members of the NPA. We are also assuming that it has been established that the purpose of killing the chief of police was because of his, or was by reason of his, alleged abuses. So there can be no other crime to be charged here but only a crime of simple rebellion. The killing of the chief of police is deemed absorbed in the crime of rebellion. Another example. NPA rebels raided the town hall, ransacked the town hall of its valuables, and killed the mayor. Here also, only a case of simple rebellion should be filed. And you might ask, hindi ba pwedeng filean ng robbery ang mga NPA rebels, Fiscal, at saka murder or direct assault with murder? Bakit simple rebellion lang? Similar to my explanation a while ago, and in accordance with the ruling in People versus Hernandez, all the other acts committed in furtherance of the rebellion are deemed absorbed in the rebellion itself. The killing of the mayor, the ransacking of the town hall, and the taking of the valuables have assumed a political character, even if by its very nature or per se, they are mere common crimes. Example number 3. X, an NPA rebel, raped Y, whom he saw bathing in the river. In contrast to examples number 1 and 2, this is a mere common crime, meaning to say what X did was a mere common crime which does not partake of a political character. Why is that so? Because in this example, the act of X, in raping Y, had no connection whatsoever to the crime of rebellion. It was not committed in furtherance of rebellion, neither was it committed during the course of the rebellion. So, in this situation, only the common crime of rape should be filed against X, or the common rape na not rebellion should be filed against X, even if even if it is established that X is an NPA rebel. Example number 4. X, an NPA rebel, has a personal grudge against Y. X thereafter killed Y. Similar to example number 3, this is also a common crime. Only a case for homicide or murder, as the case may be, can be filed against X. His being a rebel is not material or has no bearing to his decision or to his act of killing Y, whom he has a personal grudge with. Another example, X, a rebel, was caught in possession of an unlicensed firearm. Under Section 29 of Republic Act 10591, the law particularly states that if his possession thereof is in furtherance of, or incident to, or in connection with the crime of rebellion or insurrection, such violation shall be deemed absorbed as an element of the crime of rebellion or insurrection. Meaning to say, X here will only be charged of rebellion aggravated by the use of an unlicensed or loose firearm. So this is similar to the ruling in People versus Hernandez, that all other acts committed in furtherance of or during the course of the rebellion shall be deemed absorbed in the latter. Example number 6. Take note of this. Let's say 7 NPA rebels raided the town hall, ransacked the town hall of its valuables, raped the mayor's wife, and thereafter killed the mayor. How many common crimes are committed here? Assuming that these 7 offenders are not NPA rebels. How many common crimes are committed here? Ransacking the town hall of its valuables, robbery, raping the mayor's wife, rape, killing the mayor, murder, or direct assault with murder. So, or you can say that if these 7 people were mere private persons or private individuals and not NPA rebels, the crime of robbery with homicide can be charged against these 7 offenders. But because these 7 offenders are NPA rebels, and let us say it is established that they raided the town hall, ransacked it, and killed the mayor in furtherance of the rebellion, then all these acts will be absorbed in the crime of rebellion. And you might ask, Fiscal, what about the rape of the mayor's wife? Raping the mayor's wife is not necessary, or is definitely not in furtherance of the rebellion. But take note that in the case of People versus Hernandez, all crimes, not just committed in furtherance of the rebellion, but all crimes committed during the course of the rebellion, which is the situation obtaining in example number 6, will also be absorbed in the crime of rebellion. Meaning to say, the rape of the mayor's wife, even though not in furtherance of the rebellion, but since it was committed during the course of the rebellion, as shown in this example, then only a case of simple rebellion pursuant to the doctrine in People versus Hernandez should be filed. That is, to make rebellion absorb all other offenses committed in its course, whether not necessary to its commission or in furtherance thereof. Example number 7. Senator Enrile was charged with the crime of rebellion with murder and multiple frustrated murder, which he allegedly committed during the period of the failed coup attempt from November 29 to December 10, 1990. The Solgen contended that the ruling in Hernandez doesn't apply because Hernandez merely prohibited the complexing of rebellion with common crimes if the latter were committed in furtherance of the rebellion, but not when common crimes are committed on the occasion of the rebellion. The Solgen further contended that the case which they filed against Enrile and some other people, including Honasan, was rebellion complexed with common crimes committed on the occasion of rebellion. The SC, however, did not agree with the Solgen. It ruled that Hernandez remains binding doctrine operating to prohibit the complexing of rebellion with any other offense committed on the occasion thereof, either as a means necessary to its commission or as an unintended effect of an activity that constitutes rebellion. So there is therefore no complex crime of rebellion with murder and other common crimes, because that was the contention of Senator Enrile, that there is no crime such as rebellion with murder or rebellion with complex with other common crimes. He disputed the application of Article 48, and the Supreme Court sided with him, no? That with respect to the crime of rebellion, all crimes committed whether in furtherance of or on the occasion thereof, meaning all crimes committed in the course of the rebellion, even if it is not necessary to commit the crime of rebellion, they will all be absorbed in the crime of rebellion, such as there is only one single crime of rebellion, that is simple rebellion, to be filed against the accused. It cannot be complexed with other common crimes.